Greetings. Thanks for joining us for this series of panels on calibrating data surveillance. I'm Jane Bambauer, professor of law at the University of Arizona and visiting affiliated faculty here at ITLP. My personal interest in the topic of government surveillance stems from curiosity about the ways that new methods of surveillance might wind up evading or even exploding our expectations and assumptions. So a lot of times these assumptions are implicit in the policy choices that we've made in the past. And then by realizing that the assumptions are broken, it forces all of public debate into a discussion about first principles, going back to basic questions about when government surveillance is helpful, when it's harmful, or when it's something that does a little of both for society. So for example, data that's routinely and passively collected by communication services and cell phone providers is the sort that can allow police to conduct investigations and track suspects at a much lower cost than in previous eras. And that's a fact that cases like US versus Carpenter is forcing us to grapple with right now. It raises the specter of lost privacy and other harms, and we'll discuss that in the first panel. On the other hand, digital technologies make it possible to identify a pool of potential suspects blindly based on data about whether they were at the scene of a crime, for example, or about whether they've uploaded images of child pornography. When a private company facilitates or even initiates this kind of investigation, using these types of methods, should they be welcome? Should they be seen as privacy-preserving ways to deter and detect crime that's otherwise hard to enforce? Or are they unwelcome intrusions? These questions are going to be raised to some extent in the first panel, but will also be the focus of the second panel on Apple's detection of child sexual abuse material, or CSAM. Okay, and then finally, end-to-end encryption makes it possible for criminal rings to communicate secretly, even when law enforcement or national security agencies have lots of probable cause and have secured a wiretap warrant and have done everything that we think is responsible. So many of our policies are designed in an era when major intermediaries like phone companies had the ability to provide access to these communications. So to what extent does this going dark problem justify a government's use of zero-day exploits or hacking for hire? That's the sort of question that the third panel will talk about. So we expect today's workshop to hopefully go beyond the sort of public debates that raises arguments for and against technologies used in surveillance capacities without ever attempting to reconcile the arguments. We titled this workshop Calibrating Data Surveillance in order to emphasize calibration. We're hoping that panelists can really engage in the arguments that each other bring to help us understand where the stakes are highest and where they're lowest, and where there might be room for some trade-offs between otherwise competing social goals. So with that, I'd like to introduce the moderator of the first panel. Mark Verstraete is an ITLP fellow, and he's an accomplished privacy scholar in his own right, and he will get us started with the first panel.
Thank you so much, Jane, and thank you for everyone joining us today. I'm going to start by introducing our panelists, saying a few more words about sort of the topic of the panel, and then I'll let each of our panelists give a short introduction to their thoughts about emerging issues that govern law enforcement access to data held by intermediaries. So beginning our panel, we have Michael Dreeben, who is an attorney at O'Melveny & Myers and formerly the Deputy Solicitor General at the Department of Justice. And he also argued Carpenter on behalf of the United States in front of the Supreme Court. Catherine Crump is the director of the Samuelson Law, Technology, and Public Policy Clinic at UC Berkeley School of Law. And Chris Slobogan, the Milton R. Underwood Chair in Law at Vanderbilt Law School. So typically under the Fourth Amendment, law enforcement needs probable cause and a warrant. However, there are a few exceptions. One of these is the third-party doctrine, which if you or I reveal information to a third party, our expectation of privacy is lowered according to the court, and law enforcement often does not need to acquire a warrant. And one of the most important cases is Carpenter, which examined the limits of the third-party doctrine and sort of casts new light on when and whether law enforcement needs a warrant to acquire information held by third parties. So we're going to be teasing out some of these legal barriers to access to information. When does law enforcement need a warrant? Where exactly is the third party doctrine heading? And can we abstract to new technologies, whether these will be governed by the typical warrant requirement or if they'll fall under to the exception to the warrant requirement through the third party doctrine, and whether we can abstract even further to find some guiding principles so we can make judgments about technologies that are not even in practice yet. So I'll begin with Michael to sort of offer introductory remarks about some of these issues.
Thank you, and thank you for having me on this distinguished panel. It's an honor to be here and to have a chance to talk about the fascinating and evolving issues that are raised by the intersection of technological developments and Fourth Amendment principles. As Mark said, the court's most recent encounter with these issues was in Carpenter versus United States, which involved a government request under the Stored Communications Act for cell site location information. Our phones are constantly generating digital fingerprints of where we carried them because they need to communicate with cell towers in order to work, and the cell companies aggregate that data and accumulate it and can store it as long as they want. In Carpenter, the government used the Stored Communications Act and its reasonableness standards to get information about the locations of phones of a robbery suspect. And the duration of the requests went for over 100 days. It was a long period of time. And by getting the location of Mr. Carpenter's phone, the government was able, in effect, to triangulate his location in the proximity of a variety of robberies, ironically, of cell phone stores. This gang was stealing cell phones, and the cell phones, in a sense, got their revenge. But then Mr. Carpenter turned the tables in the Supreme Court by obtaining a ruling that a warrant was required to get cell site information. This was a seismic change in the law, perhaps one that you could say the tea leaves were there for, because the court had a series of cases where Fourth Amendment doctrine developed in the analog world was very strongly on the government's side, and digital searches were more intrusive, and the court pushed back and innovated. First in Kylo, the thermal imaging case, where the government was getting the readings of heat signatures on the outside of a house, and the court said that's acquiring information that you could only get with a warrant in the pre-thermal imaging days, so we're going to require you to get a warrant for that. And then on through the GPS case, Jones, where the court tacked in a different direction and said that this was a trespassory search when the government attached a GPS surveillance device to the underside of Mr. Jones's car. But 5 justices also stood up to say, well, we think that it's a violation of reasonable expectations of privacy as well. And then you have the collision course between the third-party doctrine that Mark alluded to and expectations of privacy in Carpenter. And the Chief Justice wrote an opinion there that said, look, we've said in the past that bank records and records of dialed phone calls obtained through a pen register, that is business information that the government can go to the provider to get, and it doesn't implicate any Fourth Amendment interests of the customer. But cell site information is different. Why? The Chief Justice gave essentially 2 reasons. One is it provides a detailed picture, comprehensive record of someone's movements over a prolonged period of time, and thereby allows the government to build a very thorough picture of what that individual is doing in his life, who he's visiting, who his associates are, and so on. And the second is we are all carrying around cell phones as a kind of necessity these days, and the location information is being pumped up to the providers, not really as a voluntary communication the way it is when I write a bank check and I know it's going to the bank. You know, anyone who thinks about it knows that their cell tower is picking up their location, because otherwise how could they do the phone call? But the court said that's not really voluntary communication. And with those two aspects of the third party doctrine pushed to the side, the court said we're going to require the government to get a warrant to get cell site location information. I will leave out the really interesting doctrinal nuances about why you need a warrant to get the information, whether you would need a warrant to get the information if it were held in the individual's hand himself, what this does to subpoena law. These things are turning law enforcement and courts into pretzels, trying to figure them out because they are really quite puzzling. But I will mention just a few frontiers of Carpenter. And I think up top, it's, you know, the headline here is Carpenter has not shown very much growing power. I mean, the court itself went out of its way to say that, look, we are not extending this to real-time surveillance. Although logically, I'm not sure there's any difference between real-time surveillance and historical surveillance of cell site data. We're not applying it to tower dumps, which is when law enforcement wants to know who was near a tower at a particular time. They haven't focused on anyone in particular. I know that others on this panel are going to talk about surveillance techniques that have a family resemblance to that, geofencing. They said we're not going back on conventional surveillance, like getting bank records in Smith and Miller, the two cases that approved that kind of surveillance. They're not abolishing exigent circumstances. They are not touching security methods like traditional security cameras that are found around the community, and they're not talking about national security. So with all of that hedging, where has Carpenter gone? Last time I checked, not very far. I mean, courts have said that IP addresses are outside of Carpenter for a whole host of reasons, including that you don't get a detailed picture of somebody's life from IP addresses. Automatic license plate readers, Easy Pass, the same, you're not getting something comprehensive. The biggest push right now is probably on pole cameras stationed outside someone's house. And there's a cert petition in a case called Tuggle versus United States out of the Seventh Circuit that's knocking on the door and saying, well, at least this is really comprehensive information, and surely the principles of Carpenter apply. But so far, I would say that Carpenter is more of a shot across the bow than a life-changing viewpoint on the scope of the Fourth Amendment. And I'm just going to say two very things quickly that kind of shadow the significance of Carpenter just as much as the limits that I just talked about shadow it. And one is our data is out there. Our locational data is everywhere in the hands of private companies, because unless we are very careful to opt out, our apps aren't keeping track of where we are. And that data is being packaged up and sold by private commercial entities and used to bombard us with ads. And it's also being purchased by the government. And privacy organizations have protested that this is a workaround that violates the spirit of Carpenter, but it really stands on a very different footing. If private companies are gathering up this data and they're selling it to anybody, why can't the government buy it? At least the government is taking that point of view. And then the second area that's kind of related to this is enterprises, and all of us really, but enterprises in particular, corporations and so forth, use cloud service providers to store their data and to process it. And the government generally has a policy of saying, well, we'll go to the enterprise if it won't compromise our investigation, but often it does. So they go to the enterprises, and this cuts out, they go to the cloud service providers. And this cuts out the enterprise from being able to interpose objections like overbreadth, privilege, irrelevance, and similar things. And the government often seeks gag orders so that the cloud service providers can't tell the enterprises that this is going on. I wouldn't describe this as a workaround from Carpenter because the government is getting a warrant, but it is a way of increasing the government's ability to circumvent private entities from pushing back on the scope of the investigation. So I put a lot out there, and I'm really anxious to hear what my co-panelists have to say, so I will stop here.
Yeah, thank you so much, Michael. Thank you for the overview of Carpenter and sort of untangling some of the factual and legal nuances. I think maybe we'll go to Catherine here, with keeping in mind sort of Michael's idea that maybe the ramifications of Carpenter are slightly overblown. Maybe it's not as cataclysmic to Fourth Amendment law as many think.
Yeah, thank you so much. It's an honor to be on the panel, and it's particularly interesting to follow Michael, who, is of course litigating these issues for the government. At the same time, for a lot of that time, I was an ACLU attorney litigating these issues myself, but from a different perspective. So on the ramifications of Carpenter, I think it's an interesting issue, and there's a couple of ways to think about it. One is to look at the doctrinal ramifications of Carpenter, and I have to say, so far, I agree with Michael that it's not clear how far this will go, right? So for example, there have been some opinions addressing like real-time cell phone tracking in court, saying, okay, we're going to extend the ruling in Carpenter, which applied to historical records, to real-time tracking. That's at most a marginal change. I guess one thing to point out was that Carpenter was decided, I think, Michael will correct me if I'm wrong, in 2018, but we know the government began tracking cell phones in at least the late 1990s. So the court doctrine moves slow, and the fact that maybe what we thought was a seismic decision has in fact created minor ripples so far will be something that changes over time. There's one other issue I really want to put on the table in these introductory parts of this panel. And this is an issue that I know is not sexy, but it's important to me as someone who's been working on this from the defense side, which is just the tremendous amount of secrecy that surrounds the government's practices. So the Stored Communications Act does not require that SCA, Stored Communications Act warrants, so the warrants you might get for email or cell phone load tracking information, be sealed indefinitely, but yet that is generally speaking the practice in most federal courts. And that has had a lot of consequences. It's obscured the scale of the government's use of this technique. So we're reliant, for example, on private companies to inform us about how often these techniques are used. So for example, Google issues these transparency reports and reports on how many applications for various types of surveillance it receives. It said that in the first half of 2020, it received nearly 20,000 warrants under the Stored Communications Act, affecting 28,865 accounts, right? We don't have, obviously, near that many suppression motions or other motions dealing with these things. That's, of course, understandable. But this huge practice has grown up with very little transparency. And I know Chris is going to talk about this in more detail, but it also means that it can be very hard to figure out what exactly the government is doing, which makes it hard for defendants to file suppression motions, right, to raise these issues. So, for example, information has slowly been revealed about the extent to which the government is using these authorities to do geofence warrants, right? So to find everyone at a particular location at a particular time, perhaps correlated with criminal activity, or another investigative technique we've learned more about recently are search term warrants, where the government might seek information on all accounts that search for particular terms. And so there's this very frustrating and slow moving sort of cat and mouse game as the defense community tries to catch up to see what these various procedures are. Now, to be sure, the ones I've just described, the government is getting a warrant for generally. And I think one question you could ask is to what extent that itself is a vindication of Carpenter, right? So there's vindications of Carpenter in the courts, and then there's just vindication of Carpenter, or sort of policy decisions given trends in Supreme Court jurisprudence about the scope of search warrants. So one of the things that I actually find quite heartening is, at least when I have been reviewing search warrant applications, right, which are not necessarily that easy to come by for the secrecy reasons we've been talking about, the government actually gets a warrant based on probable cause for, the contents of social media accounts generally, for especially for the content related pieces, for geofence warrants, for search term warrants, for most types of historical and real-time cell phone location information. And so I think Carpenter has these potentially broader ramifications too. And so I think we should try to take those into account when we're thinking about the implications of the decision. And I guess I'll stop there for now.
Thank you so much, Catherine. That was a really great sort of set of introductory remarks, and I really appreciate the way you framed the possible effects of Carpenter beyond just judicial behavior. Often I've sort of cabined my focus to that, but I think, like you mentioned, Carpenter could have effects on sort of the government's behavior more generally. Maybe they seek warrants in borderline cases, and this could have sort of long-lasting effects. I want to go to Chris really quickly, and then we'll sort of open it up to discussions and sort of untangle some of the pretzels that Michael mentioned, and hopefully find areas of contention and also areas of consensus.
Okay, great. Well, both Mike and Catherine have said I'm going to talk about geofencing, so I will, but not yet. I'll wait a little while to talk about that. What I wanted to say during this introductory period is that I think there's an interesting question raised by the court's decisions, especially in Jones and Carpenter, regarding what's known as the Mosaic Theory. It's much maligned, but I think it's worth at least broaching here at this point as a way of thinking about how Carpenter and Jones might play out. So the Mosaic Theory, for those of you who don't know about it, determines whether a government action is a search or not a search by looking at the amount and type of information obtained by the investigative technique in question. So let's say, for instance, there's a CCTV system set up in a jurisdiction. Police use it to watch a person walk down the street. That's not going to be a search. There's no reasonable expectation of privacy in public travel. But let's say the police use the CCTV to follow this particular person's public wanderings for weeks on end, for months. That might be a search on a Mosaic Theory because of the amount of information being obtained about this particular person. Or let's say police go to a store to ask whether a suspect purchased a gun on a particular day. That's not going to be a search under any stretch of the imagination under current jurisprudence. But what if instead police ask for 6 months of banking information from the person's bank? Now, right now, that's not a search, but I'm raising the question about whether it might be, given the possible adoption of Mosaic Theory after Jones and Carpenter. Now, why do I say that? Well, for instance, in Jones, which again is the tracking case, 4 justices distinguished between prolonged tracking, like the 28 days of tracking that occurred in Jones, and short-term tracking. So they imply that the amount of information obtained might be a relevant constitutional consideration. And then a 5th justice in Jones, Sotomayor, stressed how technology's ability to aggregate information should be a Fourth Amendment concern. So in Jones, we see this idea that maybe the amount of information being obtained should be relevant to the Fourth Amendment. And then in Carpenter, the court held that accessing 7 days of CSLI is a search, but it explicitly avoided deciding whether obtaining fewer days would also be a search. So again, you see this idea that maybe the amount of information being obtained should be relevant to Fourth Amendment theory. And I think it makes some sense from a privacy perspective for obvious reasons. The more information the government obtains, the more the government intrudes into a person's privacy. So that ought to be something that the courts and legislatures ought to think about. And in fact, one could even argue that the definition of search should be broadened so that most of what we're talking about today is a search, and the more intrusive searches should require probable cause. So for instance, what happened in Jones, what happened in Carpenter should be a search. But if less information is sought, then maybe only reasonable suspicion would be required. And that's in fact what the Stored Communications Act does, not at a constitutional level, it's statutorily, but nonetheless what it does is it requires probable cause for obtaining the content of messages, but only something akin to reasonable suspicion. It gets subscriber information. And then if the police want to obtain phone numbers in real time, all that's needed to be shown is relevance, which isn't even a reasonable suspicion standard. Of course, the difficulty with Mosaic Theory is figuring out where to draw all the lines that need to be drawn. And that's why a lot of courts stay away from it. I don't think the Supreme Court will get into that business, but if it does happen, and I think there's some good reasons for saying it should happen, legislatures could carry out the process of figuring out where to draw those lines, as has occurred with historic communication. So I think I'll stop there. Be glad to go into geofencing, anything you want me to do, Mike, or go back to Mike and Catherine.
Great. Thank you so much, Chris, for those remarks. I think maybe one point, basically based on recency and because it's sort of very contentious right now, maybe we could focus on Carpenter. So, I mean, as I read Carpenter, I see sort of the two guiding principles that the court lays out as duration, sort of what Chris was mentioning with the Mosaic Theory. So the length of the surveillance, the amount of information that's revealed. So duration is sort of one factor in the test, along with voluntariness. So in Carpenter, the idea that owning a cell phone is essential for modern life. It's very difficult to escape it. Do any of you see these as sort of the dispositive factors? Do you see other ones sort of lurking in the shadows? And based on this, where do you see sort of new technologies being sort of filtered through this framework? So what does this mean for something like pole cameras or geofencing or automated license plate readers? And so here I sort of want to distinguish between two things. The first, sort of a prediction about what courts will do based on the principles in Carpenter, and then also maybe moving towards something a little more normative, like what do you think the rules should be based on sort of sound policy or other considerations?
Well,
Chris, why don't you lead us off?
I'll just say one thing. You wondered if the two criteria you mentioned are the only relevant criteria, and I guess you could read Carpenter to say that, but at the same time, I think it's worth throwing in another possible criterion, which is the type of information being sought. The dissents in Carpenter basically gave us a parade of horribles, that Carpenter is getting rid of the third-party doctrine. We will no longer be able to issue, the government will no longer be able to issue subpoenas for business records. Investigations of businesses will go down the tubes because you can't develop probable cause in those cases. And I think it's worth thinking about whether, in fact, and this majority pointed this out, there's a distinction between subpoenas for business records and impersonal entities on the one hand, and then attempting to get personal information about private individuals on the other. There's certainly a long line of Supreme Court cases starting way back at the beginning of the 20th century and going into the mid-1950s and 60s, which made a significant distinction between corporate records and personal records, and made the point that corporate records you can get fairly easily because there's very little privacy associated with them. On the other hand, personal individual records should be protected to a much greater extent. And I think if you adopt that distinction, a lot of what the dissent says, a lot of the concerns it expresses in Carpenter fall by the wayside. So I think maybe the type of record being sought is another criterion that ought to be considered.
Yeah, that's really helpful, Chris. So maybe the focus on information type can allay some of the fears that the dissent raises and help us thread the needle in more difficult cases. So Catherine and Michael, do you agree with this? How do you see these different factors playing out? Are any more important than the other? Do you have a preference who goes first? Michael, why don't you go first, and Catherine, you can follow.
Yeah, I do agree with Chris that the court placed some stress on the type of information that was being acquired, but all of these factors are soft. I mean, the court in Carpenter said, we're going to take 7 days of surveillance and say that at least is a search. I'm not going to tell you whether it, if you went down to 6, 5, 4, 3, 2, or 1. I think the government in the wake of Carpenter adopted a kind of 48-hour safe harbor, but it's arbitrary. And any kind of a line drawing that one does with timeframes like that is going to be somewhat subjective. And you could say, okay, fine, that's the common law process, that's what we will do. Similarly, trying to assess what kind of information is more sensitive than other kinds of information. You can find out a lot by where somebody goes. You can find out probably even more by looking at their toll records of who they call, or now who they text, and their bank records. And the court suggested no new rules applicable to those means of communications. And when I talked to investigators at the FBI, including the ones who managed the cell site program, they said, first place we go is toll records. We want to know who the person is talking to. They could be shopping at Safeway. We tried to make the point the government tried to make the point in Carpenter that knowing where somebody is in an urban area doesn't tell you where they have exactly gone to. So, drawing lines between those kinds of information is a very, very difficult task. And, and similarly, what it means to have a comprehensive record of someone. So all of those things, I would say, just to pick up on what Catherine said about influencing other actors, this is really an area for legislation. And it's so much more conducive to the legislative process to say, this is how we're going to construct a hierarchy of information. This is what we're going to make the government do. And indeed, I think you see some of that going on now. I know this panel is not talking as much about the purchasing of information by the government, but I've seen legislative hearings convened to address that issue. And it makes sense because the Fourth Amendment may not cover it. And so part of what you get out of these cases are shots across the bow, kind of warning signals of you've gone too far here, watch out for it. And hopefully it advises society that there are very important privacy interests here that need to be balanced against the needs of law enforcement. And if those get worked out legislatively, as they did, for example, in the Title III area, so we don't have very much law following on expectations of privacy and telephone calls because Congress stepped in. Congress does that. Some of these more nuanced problems may be resolved legislatively.
All right, Catherine.
Yeah, I agree with all of this. I mean, many of us enjoy the intellectual issues these questions raise, but I can't imagine many of us are very excited about having to piecemeal litigate. Is 3 days, enough to trigger this concern? How about 8? What if it's every other day? And I agree, a legislative solution would be ideal for a lot of this, but it gives me this sort of Groundhog's Day feeling, right? Because I feel like I was on this panel 10 years ago, and everyone on this side of this debate was like, it would be great if Congress, reformed the Stored Communications Act. We just never seemed to get there. And I sort of do agree with Michael that in the absence of that, what you end up with are memos from the criminal division, Michael may know this more than I do, giving guidance to U.S. attorneys' offices around the country about what to do in the wake of a big Supreme Court decision like Carpenter or Jones, right? Which I think ends up being the de facto law, right, that governs these surveillance requests. Now, of course, each U.S. attorney's office can decide what to do with the central DOJ memo, but those memos are secret. And I will tell one story, which is that in 2012, Andrew Weissman, who was then the FBI general counsel, was at a symposium at the University of San Francisco Law School, and he held up a memo saying, Jones has created chaos, and this is the memo, that we've had to issue to all of our attorneys, sort of saying what happened. And so I, being a junior ACLU attorney and something of a smartass, filed a FOIA request saying, I want the memo that Andrew Weissman held up at the University of San Francisco Law Review Symposium. And we litigated and lost on the grounds that it was deliberative process privilege. And in particular, because it didn't bind the U.S. attorney's offices around the country. And while that is formally true, I have to tell you that when I then typed in the few unredacted passages of memo into Westlaw, I pulled up all of these briefs, so it was obvious that the memo is being copy-pasted them around the country. And I just think there's got to be some public interest in disclosure about these decisions, or at the very least, a legislative solution would be better, because then we wouldn't be being governed by this de facto secret law. And I think for a lot of us, there's probably actually, we all have our litigation posturing, but there's probably also a lot of middle ground that if we had a functional legislative process, we could get to here.
That's interesting. It seems like everyone sort of there's a bit of consensus about the need for the legislative process to sort of fill the gap here? And if that's the case, what would the ideal outcome of that legislative process be? Chris, do you have thoughts on what sort of an ideal outcome of that would be for you?
I do. I have a whole book on it, but I'm not going to go into that amount of detail right now. I think the predicate questions, the one that Catherine and Mike have raised, is how do we get the legislature to do anything? I mean, Alito has sent message after message after message to Congress and state legislators saying, you need to get on the ball here. He says it in every opinion that he's written lately about these kinds of digital searches. And I would think the law enforcement lobby could get something going if it wanted to. It usually gets whatever it wants in terms of legislation. So it's got the Stored Communications Act, but there are lots of other things that aren't legislated at either the federal or state level that they could probably get the ball rolling on. And I think Carpenter provides impetus for that, because otherwise, who knows, maybe probable cause will be required for everything, horrors. We got to do something about that. So let's make sure that that's not required for everything. And I'm hoping Carpenter, in fact, does trigger that kind of legislative activity, because as all three of us have said, the courts can't do this. There are some examples of the courts coming up with guidelines. For instance, when Mike was talking about the 48-hour rule, I jotted down the Riverside case, which some of you may know has nothing to do with digital searches. It has to do with when a person has to be brought in front of a magistrate after being arrested. And the court was confronted with the argument, well, all that should be required is that arraignment be prompt. But the Supreme Court said, no, we're going to give everybody a bright line rule here so that everybody knows what's what. 48 hours. And the court admitted, hey, this is arbitrary. Maybe it's too long, maybe it's too short, but we need a bright line rule. So that's one of the few times the court has been willing to draw a line in the sand. Maybe we'll do it in some of these other situations. I think it would be much better if Congress and state legislatures would start the ball rolling, and then let's see what the courts say in response. And I want to say one last thing about legislation. You know, we shouldn't just focus on Congress. There are a lot of states that CalECPA, which many of you know about, is actually a very well done statute. It's got some flaws, yes, but it's a pretty good statute. And it does actually get very specific about some of these things. Other states have gotten specific about various types of surveillance, like drone surveillance and tracking. So that's where we should be going if we want specific rules. And you asked me for model rules. Again, I could go on and on about that. But I don't think it's worth our while for me to say, oh, it should be 48 hours as opposed to 24 hours. We could debate that, but I don't think it's worth going into that amount of detail right now.
Great. Michael, why don't you jump in?
You know, we have seen some episodic legislation in this area. We haven't seen comprehensive privacy legislation. For example, the 215 bulk data collection of telephone information, which was being warehoused by the government. And whether or not you think it's been misused, it was kind of scary when it came out. This really goes to Catherine's point about transparency, which I 100% agree with. I agreed with that when I was in the government. I thought this was too big a decision to have without the polity being involved in the process and being able to influence legislation. But Congress did step in and it imposed some restrictions on it that were privacy protective. And I think in some ways, the program was never quite as valuable as it was cracked up to be. And the restrictions on it made it even less usable. And I think it got abandoned at some point, in part because they could not keep straight which data they were supposed to keep and throw out. But that's an example. Another example is a case that the court did not decide, called United States versus Microsoft, which had to do with whether a 2703 Stored Communication Act warrant could require the disclosure of information that a cloud service provider had decided on its own to store overseas. Microsoft said, we're sending off our data to Ireland. You know, you can subpoena us here and you can serve a warrant on us here, but you can't get the data in Ireland because it's extraterritorial. And the government's position was, well, the disclosure order acts on you here in the United States, and you can repatriate that information and comply with it. just the way that somebody who's hit with a tax judgment, has money overseas can get the money from overseas to pay it. The court didn't resolve that question because Congress did step in and enacted something called the Cloud Act, which validated the government's position that Microsoft and others had to turn over this data. And it also created a reciprocity system for the United States to work with foreign governments so that they could get information about their citizens that was held in the United States. So it's not the case that there's never legislation, but it takes something special. I mean, especially in this environment where legislation is kind of broken down even on the most basic necessities of human life. Privacy doesn't always rise to the top. And so I suspect that as much as probably Chris and Catherine could draft model legislation that would have most people in the United States thinking that's right, it may not be forthcoming. And the last thing that I will say about that is Chris made the point that, well, law enforcement could ask for it. And law enforcement rarely has that incentive. What law enforcement needs to enforce the law is information. And the more barriers that you put up to getting that information, the more that they can come up with examples of serious, child sexual abuse or other terrorist problems that seem pressing and that you need to get information, and you don't always have probable cause to get that information. That's what investigations are all about. So I would not probably expect the federal government, at least, to be extremely forward-leaning on imposing shackles on itself when it comes to getting information.
Great, Catherine?
Sure, that makes sense. And I'm glad we agree on the transparency piece of it, although I'm also unsurprised because at the end of the day, most government folks I talk to seem to agree on the transparency piece of this. I mean, the other thing that I think I just might put on the table is that in the absence of legislation, it also feels like a lot of power has been delegated to the corporations, right? So one of the issues that, as sort of someone on the defense side of this, that I've been quite concerned about is not just whether law enforcement gets a warrant, but the scope of those warrants, right? So for example, do you get the whole account or do you get the count from the date of the incident forward is from a practical perspective to me a big deal. And it seems that for the most part, it's corporations who are ending up making these really key policy decisions. And so in the geofence warrant, for context, for example, the government and companies, primarily Google, seem to have worked out this system whereby, so a geofence warrant gets all of the location information at a particular scope location. It's generally drawn on a map during a particular time range. And as best I can tell, and others may have more information, correct me as I'm wrong, the usual protocol is first, the government will produce, the Google will produce sort of a set of kind of anonymized data of who's hit or if anyone's hit the tower during the relevant period in the relevant location, and then the government will ask for de-anonymization. But that, as I understand it, is sort of has just become a privacy protective process that's evolved out of the corporate space. And so I feel like a lot of power here is being delegated to the same companies that seem to have a lot of other power over our digital lives.
Yeah, I can follow up on that. It seems like a good time to talk about geofences, since Catherine just mentioned it. And you basically, Catherine, has accurately described the process. Google has pretty much been in control of this in many jurisdictions, and they've come up with their own way of approaching geofencing. Let's say a murder happens outside the building right now. One way of trying to figure out who did it, who might have witnessed it, is to get the phone numbers of phones that were near the scene of the crime at the time it happened. And so police have started doing that quite frequently. It isn't often successful, but sometimes it's been useful. And Google's forced them to go through a three-stage process. They get the initial data dump, which is basically all the phones near the crime scene at the time it happened. And then based on that information, and by the way, this is all anonymous. They don't know who belongs to the phone. They just know what the phone numbers are. And then they, based on what they get, they perhaps look at what phones were near the crime scene for a long period of time, focusing on those and ask for more information about where they came from, where they went to, in hopes they can get more information about people who may have witnessed the crime or actually perpetrated it. And then the final stage is the unmasking. When they narrow it down to a couple of phone numbers, they think these people probably were involved in the crime. We need to know who they are. And Google's required court orders at all three of those stages. The courts haven't. I think the courts are going along with it, and they're doing it. But as Catherine said, it was a private company that sort of set up this particular way of doing things. I guess what I'll say briefly about it, and maybe we can have more discussion, is that some courts have been quite willing to go along with this, but other courts have refused to issue any kind of warrant in this situation on the not unreasonable ground that at least during the first two stages, you don't have probable cause or even reasonable suspicion with respect to any particular phone, right? You might be looking at scores of phone numbers and you have no idea which phone belongs to the perpetrator or an eyewitness. And of course, it may be the perpetrator didn't have a phone at all. So you just don't know. You don't have what's usually called individualized suspicion. So some courts think this is a general warrant and they won't issue it. Other courts will issue this kind of court order. I shouldn't call it a warrant because it is a warrant. And you have to start particularity of the person to be searched based on probable cause to believe the person is involved in crime. You don't have that for all the reasons I've been talking about. But some courts have been willing to issue the order, other courts have not been. I think actually I side with the courts that have been willing to go along with Google's process, that have issued the orders, so long as, and this is what I think Catherine in part was referring to and they want to talk about, so long as some facsimile of the particularity requirement is adhered to. In other words, the police are required to define pretty clearly and confine pretty substantially the area that's going to be geofenced and the time period for which they get phone numbers. And then they go through each of these stages, successfully narrowing down the phone numbers that are of interest. And only when they've narrowed it down significantly and the judge thinks they've narrowed it down in a logical way, whether it be the unmasking. And I think this is what I'll end with, for right now at least. There's actually a Supreme Court case that is relevant to this. And it's not Carpenter, it's not Jones, it's not any case we've been talking about so far. It's a case called Illinois versus Lipscomb, which is a checkpoint, which involved the police setting up a checkpoint 1 week to the hour after a hit and run accident occurred at the same location where the checkpoint was set up. The idea being, we'll stop cars at this checkpoint and see if we can identify eyewitnesses or maybe even the perpetrator of this hit and run incident on the theory that people use the same route commuting every day. And the Supreme Court upheld it. Notice that there was no individualized suspicion whatsoever with respect to anybody being stopped, but the Supreme Court upheld it because of the nature of the crime. It was a serious crime, someone died. The fact that the seizures were minimal, there wasn't much in the way of privacy or autonomy infringed upon with respect to the checkpoint. And there was an attempt to minimize the number of people stopped. In other words, it was calibrated, use the word, that's what the title of this conference, to the time and place of the hit and run incident the week before. And I think you could say the same thing about geofence. So long as some version of particular requirement is applied and we try to narrow the geofence, the actual intrusion is very minimal. I mean, first, it's anonymous for the first two stages. It's only the last stage there's any identification of individuals. And even then, all you find out is where a person was at a particular point in time, which is not a stunningly private piece of information.
Great. Thank you so much, Chris, for teeing up geofencing and sort of addressing some of the attendant issues. Catherine, do you want to jump back in with geofencing?
Yeah, just briefly to say, I basically agree with that. And a lot comes down to the details of how the warrants are drafted. So for example, one of the things I've been doing recently is reading the warrants filed in the District of Minnesota in the 6 weeks after George Floyd was murdered. And there's just, it's just a really interesting collection of documents. And there's a geofence warrant in there because 3 people went to the post office and broke into the post office and stole a bunch of packages, and then the post office got boarded up, and then they came back the next day. It was 3 people. They didn't know who the 3 people were, but they both had them on video surveillance footage, and they could see that they were using their cell phone flashlights to illuminate the location. And so then law enforcement agents filed a geofence warrant request for basically like the half-hour period during which the people were on video in the post office, right? And they definitely had their phones, and it was a sort of tight geographical location in which it was unlikely to sweep up a lot of additional people. And I just have a hard time seeing what's wrong with that from a sort of a policy perspective or a particularity requirement. So I am not in the camp of people who think these warrants are just across the board general warrants, but I do care about the details. And by the way, when I see things like this, my reaction is to feel reassured, right? And so the extent geofence warrants look like this, some transparency might actually serve the function of reassuring the public, because although these warrants are public in Minnesota, that's actually pretty unusual.
So what I think is really interesting about this this discussion is that it kind of illustrates on a practical level what I think is legally true, the limits of Carpenter. I mean, if you're picking up an individual under a geofence warrant and you're getting that individual for as limited a period of time as Catherine and Chris have described, it's not clear to me that they have a reasonable expectation of privacy. I think arguing that they do is very difficult in light of the reasoning of Carpenter. And then you layer on top of that something that is quite important, which is how do the companies that hold this data respond to it? The description of the 3-stage process where Google is really being somewhat, protective of people's privacy in a way that is probably, applauded by people on this panel, and maybe good also just from a point of view of law enforcement shouldn't scoop up troves of personal data that it does not need. There are situations in which kind of the opposite is true, and that is email search warrants. Catherine began to allude to this, but typically the provider is not in a position to do screening on what is relevant within an account. So you could, for example, have probable cause to believe that a particular individual is involved in a mail fraud scheme that pertains to, a product and is communicating with 2 or 3 possible confederates. You cannot expect the providers to do the sort of screening and analysis of the email account. You can limit it to relevant temporal events, and then, in that sense, not turn over everything that's in the account. But the government does get the whole account. And in the course of searching that account for the relevant information through keywords, and then ultimately through, a human observation, maybe someday we'll get to the point where AI will do it all. I don't think we're there yet. The government runs across all kinds of other information, and part of that could be considered a gratuitous or at least a incidental intrusion on privacy. And part of it could result in further criminal liability because of the plain view doctrine, which to date has not been totally settled out, but an orthodox pre-digital version of the plain view doctrine would say what you see from a lawful vantage point in the course of conducting a search you can use. And maybe it's not an in-depth translation of everything from Russian that you see in an account, but a cursory look at what you see in the account would fall within the plain view doctrine. And I'm interested in other panelists, whether they think that Oren Kerr's suggested revision of the plain view doctrine is warranted or unwarranted under those circumstances.
Chris, it looked like you wanted to go.
Yeah, I'll get to Oren's point of view in a second. I want to make a doctrinal point first, which may be a little bit too nerdy, but I still think it's important to realize that the Supreme Court got rid of something called the mere evidence doctrine back in the 60s, which used to limit the scope of government searches. The police could go after contraband and fruits of crime and instrumentalities of crime, which weren't very narrowly defined, but at least they did constrain what the police can go after. But the Supreme Court got rid of the mere evidence rule, which I think opened the door to exactly what Mike was just talking about. The government doesn't have to be very specific about what it has cause to get. I mean, if you look, for instance, at the stored communication, well, 2703D, which is in the federal statute, which allows the government to get lots of different kinds of information that's produced digitally. The language is as follows. The government needs to demonstrate specific and articulable facts, which sounds pretty good, right? Showing there are reasonable grounds to believe the records or other information sought are relevant to an ongoing criminal investigation. That's not only probable cause, it's not even reasonable suspicion, really, because basically all the government has to show is articulate some way in which the records sought will be somehow relevant to the investigation. That's an incredibly broad standard. And I don't think it could exist if the mere evidence rule were still around. But the mere evidence rule is gone, and therefore we can get these relatively broad court orders that allow what Michael was just talking about, vast amounts of records that have lots of personal information in them. As to Oren Kerr's approach to it, I have to admit, Mike, I don't remember all the details. I don't have a problem with allowing the government to seize evidence that's not listed in the court order if what they're looking at the time they see the evidence not listed in the court order is something they're allowed to look at under the court order. So it all depends on what the court order allows them to look at, and that goes back to their evidence point.
So the reason why I think this is significant is sort of the analysis in Riley versus California about cell phone searches. And this is cropping up also in the context of border searches of cell phones. And everything is on them and it can be hidden anywhere. So if I had probable cause, for example, to search Chris's phone for evidence of mail fraud, I could say, well, he could have hidden it in an image. So I can look at the images. It could be in a chat with his friends, could be in a message app, going out to the cloud, looking at the bank, that is perhaps a little bit more debatable. Probably can't do that. Probably have to turn off the access to the internet. But basically, you can look pretty much everywhere, at least cursorily. And because so much information is stored on the phone, the argument is that, in effect, any warrant for a digital device becomes a general warrant. And when you combine it with the plain view doctrine, it means that the government can look everywhere on the device, even if it has probable cause only for one particular episode, and it can use any of that against you in a criminal case. So that is an area, I think, where there is friction between the doctrines that used to prevail and the implications of a digital device. And so far, that battle was being fought out in the Ninth Circuit in a case called CDT for years. I think ultimately the proponents of trying to limit what the government could look at were having the worst of the battle, and their biggest chieftain was Judge Kaczynski, who's no longer fighting it on that court. So that to me is almost an area where you will need a legislative compromise to achieve whatever it is we decide is fair. And I think we could actually debate what it is. And I'm not sure that I know the answer to that.
Catherine, why don't you jump in?
Sure, yeah. I mean, I do appreciate the point that the CSAM images are unlikely to be in a desktop folder labeled CSAM, and so therefore a broader search is necessary. I mean, I'd like to take, to the extent we can, a practical approach to this. I'm sure everyone else does too. And so when it's nice from my perspective, or privacy protected from my perspective, when the warrant, for data related to a particular incident, getting the Facebook account, right, for example, has some reasonable temporal limitations. I mean, the other, and I think this is why a legislative solution is probably in order here. Another thing that I'm concerned about with seizures of electronic data are subsequent searches, right? Because there is just so much richness in the data, those subsequent searches, right? So gathering the data for one point, then you've got it, right? Regulation of whether the government can conduct a subsequent search for it, unrelated purpose seems to me a much bigger deal in this context, and one of the areas in which I think restrictions would be warranted, beneficial. I should not say warranted, since that term has a legal meaning that we're often using.
And the subsequent search issue is tough under existing doctrine because the test is, an objective one. It's not what the law enforcement officer subjectively wants. It's what the terms of the order authorize. And the way the Fourth Amendment is structured is it protects against the invasion of privacy. Once that invasion of privacy has happened, there is no more Fourth Amendment protection. I mean, the exclusionary rule exists as a judge-made doctrine to reinforce the protections of the Fourth Amendment, but it doesn't violate the Fourth Amendment to use illegally seized evidence in court. And in fact, it happens all the time with the good faith exception and so forth. So you end up with the problem that Catherine put her finger on as being huge. And at least one court, the Second Circuit, in a case called Ganius, tried to grapple with that. And Judge Lynch, I think he wrote a joint opinion, maybe with Judge Livingston, and it's a really elegant disquisition of the pros and cons and nuanced questions of when there's a second search that's permissible and when there's not. And then they said, but we're not going to decide it here because of the good faith doctrine. So we have very little law that illuminates it.
Chris, do you want to jump in? Oh, wait, Chris and then Catherine.
Well, I just want to point out that this is definitely a real problem, but it's been with us ever since we started wiretapping. I mean, the Title III, which regulates electronic surveillance, requires police to minimize their interception based on what the warrant allows them to do, but that's very hard to implement. And so you have not only a plain view document, you have a plain hear document. If you happen to hear information about a separate crime, you can introduce it into evidence so long as when you were listening, you were within the confines of the warrant. How do you minimize? I think at one time the FBI had a rule, well, if we don't hear anything incriminating within 3 minutes, we will not listen any further. Well, for obvious reasons, that doesn't make a lot of sense in a lot of cases. And we have the same kind of thing now going on digitally. It's been a problem for a long time. We just have a new version of it now.
Yes, I mean, so I appreciate and concede Michael's point about where current doctrine is and also the longevity of the problem that Chris has pointed out. I just think this is one of those issues where courts are going to be sympathetic to defendants, right? I mean, I don't agree sort of as an intuitive matter that a subsequent search is not an additional privacy violation, right? The idea of the government keeping your information and searching it indefinitely rather than doing the search and then destroying it, right, just seems like a greater invasion. And I realize it doesn't square well with current doctrine, but if I were an enterprising civil liberties lawyer, that's one of the areas I would be pushing on for change. Building off, of course, with that Ganius case. This also come up incidentally in the border search doctrine because some people have filed motions for return of seized data, and the question is whether you're entitled to this physical device, but what happens to the underlying information? Can the government keep a copy of that? So I think there are inroads that could be made here.
This is a little bit of a tangent to the kinds of digital data that we've been talking about. But I've always been fascinated by the acquisition of DNA and what you can do with DNA, because the government has successfully argued that people abandon their DNA by shedding cells when they drink a cup of coffee or smoke a cigarette or use a tissue, and then it's gone. The government can pick it up and analyze it. And I have always felt that that was an area that seemed like unrealistic, that, are people really voluntarily giving up their DNA and allowing the government to do whatever it wants with it? I have a different, I think, view on identity DNA than some people. I'm not a huge proponent of identity DNA secrecy. But the remaining information that you can get out of DNA about people's genetic propensities to disease or other things does seem to me to be something that there's a pretty strong expectation of privacy surrounding. And yet right now, once the government's got the DNA, it can search it. And I'm not aware of any case that has said that the government needs a warrant to do that.
Chris, why don't you talk about DNA?
Okay, So I was going to ask Mike a question about what he just said. A warrant to search DNA. You mean, are you referring to the familial matching process that both federal and state officers use fairly routinely, as in the Golden State Killer case? Or you're talking about some other kind of situation?
You know, I was talking more about the probably hypothetical situation of where once the government has DNA, and it's treated as abandoned because you left your cells on the coffee cup, it can do whatever it wants. I think that, you know, the familial DNA and all of those questions are somewhat derivative. Once the government has my DNA, you know, searching against some database that it gets elsewhere, I don't think raises a Fourth Amendment issue at all. And as I said, I am not persuaded that the deriving identity information from, you know, DNA that is otherwise so-called junk DNA is a huge intrusion on privacy any more than it is picking up somebody's fingerprints and using them.
Yeah, well, I think in some ways, believe it or not, this is similar to geofences. Most of the time, the government's not getting the DNA overtly off of someone's coffee cup. It certainly can do that, it has done it, and you're right, the court usually say that's not a search. And I think I agree with you that there's certainly no voluntary abandonment in those cases, but usually they get the DNA from a crime scene. And then what they try to do, and they think it's the DNA of a perpetrator. So what they try to do is match it either with the government database, and right now we've got millions of people in the government database because the federal government gets the DNA of everyone who's been convicted. And in many states, it's not only people who've been convicted, but people who've been arrested. In some states, it's people who've been arrested even for minor crimes. So there are millions and millions of DNA, junk DNA in state and government databases. And then you add to that the fact that there are all these direct-to-consumer companies like Ancestry.com and 23andMe that have the DNA of other people. And by the way, many people in government databases tend to be disadvantaged individuals, people of color. If we can't find the perpetrator there, as was true in the Golden State Killer case, we go to the Ancestry.com and the 23andMe's, where there are people who have been trying to find out who their ancestors are, and there's junk DNA there. The government gets a match, either direct match or familial match, and moves on from there. It's a fairly limited kind of search. All they're finding out is about someone's family tree. They're not finding out any medical information. And of course, if they want to investigate further, they're going to have to interrogate or ask for the DNA or maybe get it covertly. So in some ways, it's limited in the same way geofencing. I don't know if we're getting too far afield for you, Mark, but you asked me about DNA, so.
Yeah, no, that's great. I'll give Catherine the last word on sort of, unless.
Nah, I don't have much to say about DNA, so
okay,
go ahead.
Totally fine. Yeah, so I think at this point I want to open it up to a few questions from the audience. So if people will raise their hand in the queue, then hopefully I can figure out a way to unmute you and you can ask the question. But I see Jane raised her hand, so I'll go ahead and start with her.
Okay, hi. Thanks. This was exactly what I wanted to see in a panel like this. You've really found the kind of metes and bounds of areas where reasonable minds, even coming from different perspectives, can agree. So one thing that worries me about the type of shot across the bow case like Carpenter is that even if it inspires legislatures to get off their butts and come up with some solution, it in the process tends to increase the style of Fourth Amendment privacy that the court has recognized so far, and limits the option. So let me explain what I mean. If the Fourth Amendment were to just completely undermine and obliterate the third party doctrine, I think that the legislature would be limited from taking into account certain things that Fourth Amendment doctrine historically has not, like the severity of the crime, right? So we have a lot of Supreme Court precedent that says over and over again that probable cause is probable cause, and it's required at the same level, whether we're talking about the minor crimes that Chris just referenced, the DNA databases are using for, or murders. And this has always struck me as weird, and I know other scholars like Craig Lerner have written about it. But the other way in which a type of crime should arguably be a factor is in terms of how difficult it is to detect the crime. So we might, I think it would make sense for legislatures to take into account not only privacy, but the law enforcement access to the sort of information you need to even get an investigation really started and on good footing. So I guess I'm curious what the panelists think about the type of crime as a factor that should or should not be taken into account, and what you think also of the Supreme Court's unwillingness to use it.
I'll give Catherine the first chance to respond here.
Yeah, I mean, I understand your broader point to be that if the court raises the constitutional floor in certain respects, that then limits legislatures' ability to then take other potentially reasonable criteria, such as the severity of the crime, into account. And I think that's broadly true. I don't know, but since we've now all been on panels about congressional reform for 20 years without there being much other than incremental congressional reform, I'm pretty sympathetic to courts. I have fewer opinions about the severity of the crime issue, right? I mean, the privacy invasion is arguably the same for the same data. On the other hand, the government's interest is greater. So to the extent we generally think of this as a balancing, that probably is a reasonable way to do it. But that's all I have to say about that.
Chris, jump in.
Yeah, I have a problem with taking the seriousness of the crime into account, at least in determining whether something's a search, which is at least what we started talking about on this panel. It seems to me the intrusion's the same whether you're going to someone's house to solve a murder or to solve a misdemeanor, and we shouldn't relax the probable cause requirement or the warrant requirement just because we're going after someone we think committed a murder. Now, once we've decided something's a search, it's conceivable that the nature of the crime should be relevant. In other words, in figuring out whether the search is reasonable or not. But even there, I've got some problems with saying, oh, well, you don't need probable cause or warrant. You can go with reasonable suspicion if it's a murder. Because, again, I think the intrusion is the same regardless of what the crime is. The one caveat I'd make to that is if you're trying to prevent a bad thing from happening, then maybe we could lower the requirements for reasonableness. The reason being that it's a different scenario when you're trying to prevent a crime as opposed to trying to solve a crime that's already occurred. There's more of a government interest involved when prevention is the goal. And then finally, with respect to seriousness of the crime, I think the converse, though, maybe should not be true. In other words, if it's a minor crime, as I suggested earlier, we perhaps should prohibit entirely some kinds of particularly intrusive kinds of searches. For instance, I think the DNA investigation in connection with the misdemeanor should be off base, out of bounds. And the precedent for that is, for instance, the Supreme Court case of Welsh versus Wisconsin, or even the Lang case that just came down recently, which distinguishes between misdemeanor searches and felony searches.
Great. Michael, do you have thoughts?
To an extent, on the severity of the crime issue, Congress has already shown some interest in doing that kind of work. Title III restricts wiretaps, which are viewed as a particularly intrusive kind of surveillance technique, to a list of crimes that are thought to be serious. It's difficult to make the list of crimes map onto seriousness. I mean, misdemeanor crimes of domestic violence are pretty serious. So, just drawing a categorical line based on grade of punishment may not be perfect. But I do think that, at a high level, if you're talking about at what cost do we want to permit law enforcement to investigate particular activities? How much privacy are we prepared to give up in the interest of law enforcement? I don't think courts are going to be great at doing that balance. Even cases that Chris was alluding to, Welsh and Lang, they're kind of crude. and they don't end up with a perfect match. So this is once again an area where the courts can set kind of guideposts that then are useful for legislatures to fill out with the details, but probably that would be the way that it would have to work if we want some some sorts of surveillance techniques to be, reserved for the more serious kinds of offenses.
Can I ask a quick follow-up? I'm a little surprised that Catherine and Chris's response. So let me propose something that a legislature could do that I think maybe would be more attractive in terms of taking seriousness of the crime into response. What if what the legislature did was exclude evidence that winds up being discovered through the sorts of searches that you were describing, earlier, the sort of search where you're looking at a computer based on probable cause for one type of crime, you discover other crimes. If those crimes are less serious, they could be excluded, right? So is that the sort of would that interest you in terms of using it to calibrate this trade-off?
Either, Chris, why don't you go first?
I guess if we're going to accept the plain view doctrine applies in a given situation, I don't think I would exclude anything. But I'm not sure about that. I mean, I guess if the rule is based on Welsh and Lang that you can't do intrusive searches for misdemeanor kinds of crimes, then maybe I'd exclude in that situation. But otherwise, I wouldn't differentiate based on seriousness of crime.
I think I'm more or less where Chris is. I guess the only thing I would add is that the history of these exemption lists has been that they grow over time. So I think privacy advocates may also have concerns about the sustainability of any lines that would be drawn, because legislatures may not respond to general abstract concerns about the Stored Communications Act needing to be updated, but salient media events often have a more substantial impact, leading to the additions of additional categories.
And I think when we're talking about these balances, there are so many other pieces of the puzzle that need to be brought into play. One of the things we haven't talked about at all is encryption, which sort of can disable the provider from complying at all, even if the government has the best probable cause in the world, and providers have some flexibility about whether they allow backdoors. And I realize there's another panel talking about going dark, but it does seem that it is a relevant piece in acknowledging that this isn't just a kind of legislative calculus based on what does law enforcement need versus what are the privacy expectations we want to preserve. So much data is already out there in private hands that in a sense, the debate may have way moved beyond the sort of more limited traditional range of Fourth Amendment interests that we've been talking about.
Fantastic. Chris, it looks like you want to give a quick response.
Well, we're not supposed to focus on encryption, right? On this panel, another panel can be talking about it.
We're going to be talking about the later panel, but if you want to give a quick
I just want to make
reply.
one point about it. I mean, I think the fact of encryption is relevant with respect to analyzing the privacy issue. If something's encrypted, you might say there's a very high expectation of privacy in that information. So perhaps in that kind of situation, you would need something like a Title III warrant, in other words, a super warrant. You need not only probable cause, but also a showing that the information is crucial and absolutely necessary to get it in order to make the government's case. But if you can make that showing, then I think the Fourth Amendment interest is satisfied. Of course, you've got other concerns. You've got Fifth Amendment concerns. You've got the All Writs Act, and I guess the other panel can talk about that a lot. I don't have a problem with decrypting information that's been encrypted so long as probable cause plus is shown. But I think Mike's right. You've got to think about encryption because it's becoming more and more prevalent.
Great. I think we have time for one more question from the audience. Just raise your hand and then you'll be unmuted and then you can ask away. All right, I see one hand.
Hi there. My name is Yale Makagan. I work in the privacy office at the County of Santa Clara. Great discussion so far. Just wanted to make a quick comment and then ask what I think is a relatively basic question. The comment is based on the interesting discussion around Google. And it's, in my opinion, my guess is that it's not Google, it's some individual within Google that made the decision to take this approach. And I always think about that because, it's the same thing with the idea of crafting legislation where, that's just the first sort of step. The second step is who is actually going to implement it? What is the infrastructure that is created to carry out these rules? Who's doing the interpreting on the administrative side? So, I like to think about these kinds of things in terms of the individuals that are involved. I know we talk about the sort of the companies as a convenient way, or the entities as a convenient way of thinking about them. But, somebody within that organization felt empowered to take this approach. My question is for Michael. You mentioned that the folks in the example that Catherine was giving, who were entering the post office, likely had a much lower expectation or non-existent expectation of privacy. And I just wanted to ask, if you could explain what is that based on? Do you have a lower expectation of privacy if you're committing a crime, or is it what are the factors perhaps coming out of some of the cases that you were talking about, where in that instance your expectation of privacy would be lower?
Thanks for the question. I think that the example is one of getting a limited amount of information about somebody's movements in a public space. And so Carpenter is an inroad over the prior cases that the courts had, the court had examined in Knott's and so forth, in which the court had said, if you're moving around in public, you really don't have an expectation of privacy. Your public movements are accessible to any passerby, anybody who follows you, and the police are no different. And Carpenter drew a different line with respect to digital tracking of one's movements. But as Catherine and I were discussing earlier, it cut the line off at 7 days and left open whether shorter periods of time would fit the rationale. And some of the rationales might fit, like lack of voluntary provision of information would seem to be true for all points when you're carrying your cell phone and the information is picked up by a tower. But the sensitivity of the information that Chris stressed and the detailed comprehensive record that the court itself stressed would not exist with one data point, particularly over a short period of time. So it didn't really have anything to do with the criminal conduct or what you were doing, but it was the fact that you're being observed in public by means of the electronic record of where your cell phone went for a very short period of time. And that would seem to fall, if you were doing a kind of common law analysis of which case is this more like, it would seem like it's less like Carpenter and more like a Knott's type case. That was what I was thinking.
It's sort of the Mosaic Theory at work, you could say.
Great. I'll give each of you a chance to say any final words that you may have, and then we'll end the panel there. Remarks? Okay, yeah, sorry to put you on the spot. Oh, Chris, do you want to say something?
Only
No?
because I felt compelled to. I think we still need to see how Carpenter plays out. There's a very interesting article coming out in Harvard Law Review, which looks at what has happened so far and tries to come up with some conclusions as to what the courts have done with Carpenter. So those of you who are interested, take a look at that article by Matthew Toxin. But I think the repercussions of Carpenter are going to be coming down the pike for many years to come. And it's hard to predict what they'll be.
Right, so my understanding is you think it'll have broad ranging effects, particularly in sort of judicial decisions that we'll see sort of at the circuit level. And
I'm hoping it will. I don't really want to predict. I've been bad at that over the years.
yeah. Great. Well, I want to thank each of you for joining us. I think the panel was really illuminative for me, especially particular thinking about sort of the potential for Carpenter to shape both judicial behavior and sort of the response by government lawyers and police departments, which is sort of a broader view that I hadn't really sort of incorporated in my own thinking, and also helping to think through some new technologies that I wasn't really aware of, particularly geofencing and untangling all of these thorny pretzel-like issues in Fourth Amendment doctrine. So thank you each so much, and thank you to all of our guests for their attendance as well.
Thank you, Mark.
Thanks so much,
Thank you.
Mark.
It's fun.